And thank you very much for joining this particular episode in huge numbers. I think we have a huge, and we broke the record today.
So, good morning, everyone, and welcome back to our weekly webinar series. At episode number 161 today, we talk more extensively about Bhushan Power and Steel judgment. Over to Anil, sir.
Thank you, Ankit. So, we in fact released a short video on this judgment of Bhushan Power and Steel versus GSW Steel. Since this very next day after this judgment was given by Honorable Supreme Court, the entire country is talking about this judgment, and there was a demand that, because we also felt that the entire analysis could not be done in that short video, so therefore we thought of giving a detailed analysis of this judgment in this episode, which is 161st episode of AAA Weekly Webinar Series. While I welcome you all, I definitely would say that this judgment has a greater impact on the IBC regime. We will discuss in detail. First, we will discuss the brief about this judgment, key judicial findings and learnings for the stakeholders, what were the procedural failures and whether those were in fact significant failures or could have been condoned, and then what are the now options available with the successful resolution applicant, with the creditors, and also we collated some of the newspaper items post this judgment, and then we will give enough time as a interactive question and answer session in this particular episode. As we have said in our short video, this judgment, in fact, which was delivered by Honorable Supreme Court, has not only drawn widespread attention from the legal and insolvency professionals across the country, including bankers and the creditors, but has also raised important questions surrounding the interpretation and implementation of the IBC. The session today aims to dissect the judgment, understand its broader implication and contours on the insolvency resolution process, and reflect upon the systematic learnings to be seen from this. This judgment was delivered by Honorable Supreme Court on 2nd May 2025 in the name of Kalyani Trasco versus Bhushan Power and Steel Limited. In fact, Kalyani Trasco was one of the applicants along with many other applicants, and Kalyani Trasco was one of the operational creditor. Now, this judgment, in fact, regarding the because see, the first application was regarding the rights of the operational creditors, and when it was we will discuss like what the court said about rights of the operational judgment. See, the background goes like when in May 2017, the Banking Regulation Act 1949 was amended, and RBI was given power to mandate initiation of CIRP to banks. So this was one case out of the dirty dozen where the RBI in fact has mandated the banks to initiate insolvency, that is Bhushan Power and Steel Limited. So therefore the CIRP was initiated, and the in the meantime, while the CIRP was initiated, the resolution plan was approved by NCLT. The resolution plan was given by JSW Steels, and the resolution plan was offering 19,350 crores to secure through financial creditors. After the resolution plan was approved by NCLT, or rather, after the resolution plan was approved by COC, the CBI registered an FIR after the approval of the COC. The CBI registered an FIR, and then after the resolution plan was approved by NCLT Enforcement Directorate also registered a case which they call as ECIR, and the assets of this company, Bhushan Power and Steel, was provisionally attached by Enforcement Directorate under PML. Now, this resolution plan was offering 19,350 to financial creditors against their claims of about 47,000 crores. And out of the 19,350 was supposed to come from 8,550 crores in the form of 100 crore as equity capital, and then 8,450 crore as compulsorily convertible debentures. And it was supposed to be paid within 30 days from the issue of letter of intent by the resolution professional, consequent to the approval of a resolution plan by NCLT. Now, the proceedings, in fact, went to NCLAT because some appeals were filed by one. It was filed by Kalyani Transco, then Jaldi Overseas Pte Limited, then it was Medicarrier Private Limited, then it was CJ Darsil Logistics Limited, and also the appeal was filed against the approval of resolution plan by NCLT. Appeal was also filed by Mr. Sanjay Singhal, the erstwhile promoter of Bhushan Power. The two more statutory authorities also landed into the proceedings. One was the government of Odisha and the state of Odisha, and they were in fact claiming some of the entry tax areas and also some of the other statutory dues that they were saying. In fact, JSW Steel also filed an appeal saying that the Enforcement Directorate cannot attach the assets, and JSW in fact invoked section 32 capital A of the IBC. So this was the total appeal proceedings before NCLAT. And in between, NCLAT in fact also given a stay on the attachment of assets of Bhushan Power by Enforcement Directorate. That was stayed by NCLAT, and the final judgment which was given by NCLAT, that was one, that ED did not have power to attach the corporate debtors' assets once the resolution plan was approved. This was the first meaning of that NCLAT order. And then it was declared that the attachment is illegal without jurisdiction. Therefore, NCLAT passes a common judgment and order, and the resolution plan which was approved by NCLT was upheld, and with some modifications and clarification that was, of course, that was also acceptable to all the creditors. Now, one, that this judgment of NCLAT was appealed before Hon'ble Supreme Court, and the appeals, as I said, the appeals were filed by Sanjay Singhal, the erstwhile promoter of Bhushan Power, and 4 or 5 operational creditors, state of Odisha, government of Odisha, and then the COC also filed an application. During the hearing, the COC also filed an application to place on record some additional facts. And those additional facts were that JSW Steel, letter of JSW Steel was placed before the Hon'ble Supreme Court, where it expressed its desire to implement the plan and offered to deposit the upfront payment amount of 19,350 subject to the outcome of the appeals, particularly concerning the Enforcement Directorate claim and the benefit under section 32 capital A. Also, one document was placed before Hon'ble Supreme Court where the effective date of implementation of this resolution plan was shifted it was shifted to 31st March 2021. Originally, it was 2019. It was within 30 days of the issue of letter of intent after the NCLT approval of the resolution plan, but it was delayed by about 500 days, and it was shifted to 31st March 2021 by voting, where the Committee of Creditors voted 97.25% in favor of the extension of effective date. This was something which was the Supreme Court didn't like, that the Supreme Court didn't like that the Committee of Creditors, after approving the resolution plan by NCLT, can also pass a resolution and modify the plan. That Supreme Court didn't like, to be very honest. And then the Supreme Court, like in March 21, in fact, JSW made the payment to financial creditors. 19,350 crore was paid to financial creditors in March 21, and also after some time in March 22, even the 50% of the operational creditors were also paid. And the Supreme Court on 11th December 2024, in fact, disposed of Enforcement Directorate related appeals based on the affidavit filed by the Enforcement Directorate and the consensus of the parties. Now, in this case, Enforcement Directorate, in fact, filed a consent that the attachment, we are ready to withdraw the attachment. So, therefore, no order should be passed on Section 32, capital A. So, that was placed on record, and on 11th of December 2024, based on the consent of the Enforcement Directorate, that appeal was also disposed of, and the issue of attachment by Enforcement Directorate, which was haunting this entire process of resolution, in fact, was also completely clear. Now, since December 24 till the 2nd of May 2024, the resolution plan was absolutely ready for 100% clearance. Amount was paid to the financial creditors, to the operational creditors. The ED issues were already resolved. The committee was agreeable for everything. So all the stakeholders were in fact in sync that this resolution plan, now all the appeals will be disposed of, and now there will be nothing else. In fact, the Bhushan power and steel plants were also being operated through a monitoring committee. And the monitoring committee was also having more influence of JSW Steel. In fact, JSW Steel, as per the market information, in fact, invested further more than 5,000 crores on capacity enhancement, on correction of the capacity utilization, and the total generation, the total steel which was being produced from this plant was something like 3.37 million tons per annum, which the capacity was going to be increased to 5 million tons per annum. And JSW Steel, in fact, said that with this acquisition, now they are more closer to Eastern India resources of raw material. Because see, the JSW Steel was not having any presence in the Eastern India, which is much closer to the resources for raw material. So therefore, the JSW was happy, the creditors were happy, and even the production was going up, it was being increased, and the revenue. In fact, this particular plant, which was being implemented in a special purpose entity and in a consolidation process, 13% of the revenue of JSW Steel was coming from this plant. The JSW Steel overall may have a total capacity of about 24 million tons of steel, but this was also about 13% of the total steel capacity of JSW. So that is where it was impacting JSW, and it was not expected that this kind of judgment will come. Why? Because the ED issue was resolved. As far as this EBITDA issue of 2,000 crore, the Supreme Court did not even give any order on that. As far as these claims of the government of Odisha is also not handled, because the company is now ordered for liquidation. So therefore, they can file their claim afresh. So all those things were also not decided, but because of some of the notings, because of some of the observations of Honorable Supreme Court, the resolution plan was rejected, and the NCLT Delhi was directed to start the liquidation proceedings. In fact, yesterday, on Friday, the erstwhile promoter of Bhushan Power filed an application before the NCLT New Delhi to start the liquidation proceedings of this company. That application was also filed. Now, in December 2024, the Supreme Court also directed the Enforcement Directorate to hand over. The court directed the ED to hand over JSW to take control of the provisionally attached properties as restitution under Section 8, subsection 8 of the with Rule 3A. And the reasoning was given, the direction was given considering the peculiar facts where the attachment order was passed after the NCLT had approved the resolution plan. The pending appeals, the main batch of appeals which had been tagged with the ED appeal remained pending. So in fact, the Enforcement Directorate never wanted that the Honorable Supreme Court should give any order on Section 32A. Therefore, they submitted an affidavit, gave a consent, and all other appeals which were tagged with that matter of JSW, those were in fact kept pending. And the preliminary objections regarding maintainability of the appeal by the ex-promoters, operational creditors, and government authorities was raised, which the court considered, and discussing the concept of persons aggrieved. That was something which was we will discuss after a couple of slides. Now let us understand the appellants. The appellants were different appellants, and besides the ex-promoter or suspended management, which is Sanjay Singhal, we also have the operational creditors and state of Odisha. Now the Enforcement Directorate is out now. And now the arguments from the appellants, the statutory violation, the arguments was that the resolution plan was not compliant with Section 30, subsection 2 and subsection 3 of the IBC, and did not meet the criteria for approval as mentioned in Section 31, subsection 2, as it failed to pay operational creditor equitably and on priority, and also it failed to address the avoidance transactions and fraudulent conduct adequately. The argument was that there is a discrimination against operational creditors. The JSW, in fact, reclassified some of the admitted claims where the RP was RP admitted as a claim, as a conclusive claim, whereas in the case of Jaldi Overseas PTE, the SRA, in fact, shifted that particular claim to a contingent claim arbitrarily, which is not permissible because claim admission is the prerogative of the RP. Therefore, it was considered that it is a kind of discriminatory. And also, the other issue which was being argued by the appellant, that this company has earned 2,000 crores approximately as EBITDA during CIRP period till the approval of the resolution plan or till the final effective date, which is 26th of March 2021, when this payment was made, 19,350 was made. Now, when we say that this is in fact, this particular issue was also not concluded by Honorable Supreme Court, although there are precedences in the case of SR Steel, where this kind of EBITDA was decided to be kept and stayed with the corporate debtor. It was decided to be stayed with the corporate debtor. So therefore, it was, however, in this particular judgment, this particular issue was also not decided by Honorable Supreme Court. Now, Again, the arguments from the appellant was that the conduct of JSW was malified, and the delay that they have caused, that was malified and could have been avoided. And this was the main issue before Honorable Supreme Court, because the Honorable Supreme Court, in fact, have seen in other cases also. First, it was Jet Airways. Second, it was this case. In both these cases, the Supreme Court has taken a stand that in case the approval of the resolution plan is done by NCLT, and then the effective date is shifted because of any reason, or implementation is not done because of any reason, that actually means that the intention of the successful resolution applicant to implement the resolution plan is not really justified. The Honorable Supreme Court, in fact, decided that this particular conduct is not really, it can actually spread as virus. Even it is my opinion that in case such kind of delays are permitted, in case the judicial procedures are taken to the advantage of the successful resolution applicant, and all the resolution plans are kind of delayed because of some or the other issues pending before judicial forums, and the resolution plan is not approved, that is something which actually shows that there is a malified conduct, or the delay was intentional. Delay in implementation was intentional. Now, this delay, in fact, was violating the timelines of the IBC. Then the Odisha state government claims. One was the entry tax claim. It was raised. This claim was raised only during the Supreme Court proceedings. And another was electricity duty. That was also, there was no claim before the RP. While the resolution plan was passed by NCLT, there was no claim. But the state of Odisha, in fact, appeared only before the Supreme Court and submitted that the RP has ignored their claims despite prior notice, and the resolution plan wrongly treated statutory dues as unsecured, contrary to the Rainbow Papers judgment. That's what the the state of Odisha, or the electricity department of Odisha, in fact, argued. Now, regarding the eligibility of a JSW steel, because it was also argued by the applicant that the JSW steel actually was not having Section 29A eligibility, because there was a project by the name of Nova Steel, which was between JSW and Bhushan Power, or Bhushan Steel, between the promoters of Bhushan Group. It was a company called Nova, and therefore JSW Steel was a related party. And then another issue was that the Section 32A immunity, in fact, that should be available. In fact, JSW Steel replied to this that the JSW Steel is fully eligible under Section 29A, because that particular joint venture was a very old joint venture that has already concluded, and there is no joint venture, and that any old issues cannot be brought for challenging the eligibility under Section 29A. Then the respondents, primarily the COC, primarily the JSW, said that Section 32A is applicable on IBC, because the resolution plan has been approved, and the all earlier offenses of the erstwhile promoters cannot be transferred to the resolution applicant. And also the respondent said that the scope of judicial review by NCLAT is limited post approval of the plan by the adjudicating authority. So that is the respondents, and therefore the arguments of the respondents said that we have already paid, we have paid to the operational creditor, equity has been infused, compulsory CCDs have been given. And regarding the EBITDA, the promoters and the successful resolution applicant, the successful resolution applicant said that the RFRP didn't talk about it. There was no mention in the RFRP about the treatment of this EBITDA. Therefore, the SR Steel judgment is fully applicable to this. And this amount of EBITDA will stay with the company. Since the resolution plan, it will not go to the creditors. That's what the argument from the respondent was. And as far as the timeline is concerned, it was said that the effective date was shifted by creditors by 97% voting. So therefore, that should also be considered as part of the resolution plan. And as far as this Odisha state claims are concerned, the Odisha state claim, in fact, was they did not file their claim before the RP or even NCLT and raised objections only at the Supreme Court level. So therefore, they are saying that the respondents, in fact, argued that many appellant in this particular case were not aggrieved persons under Section 62 of the IBC, as they had accepted payments under the plan or not participated in the earlier proceedings. So therefore, the questions of law. Now, Ankit, we can come back to the questions of law. And before we, in fact, come to the questions of law, because this is something which is like there are about 8 questions of law that we will one by one attend. So in case you would like to add before we go to the questions of law, you can add, or in case you can see that the some maybe questions are there, we can handle those questions at this moment. I believe since this is a completely one fiasco, so questions should be taken at end, but still you can see.
So Lalitji is saying that when fully implemented resolution plan is reversed by Honorable Supreme Court, now the assets of the CD was sold either by going concern or piecemeal. Do you think the liquidation value will be more? So how will what will be the liquidation value now when the company goes into liquidation? Then the second thing that he is commenting is procedural irregularities or filing CP by SRA resulting into delay of implementation plan and using Article 142 by the Hon'ble Supreme Court and directing the liquidation of the CD. Is it against the objectives of IBC? Though we can't comment on the judgment of Supreme Court, but seems that this is not a viable decision. That's what he said.
So one, that we can't comment on the Supreme Court decision. What we can say is that there are various newspaper items which are showing the public opinion. And we can say that in such and such newspaper, this is what is the opinion which has come from the public at large, or from the creditors, or from even Government of India. So all those opinions have come. We definitely will come back to all those opinions, whether this judgment is the how the government is thinking and how the creditors are thinking about this judgment. But I think this question that we will answer a little later, and we can actually quickly go through the legal issues which were in fact framed by Honorable Supreme Court in this case. And the first legal issue was the question of law was whether the different parties, including operational creditors, erstwhile promoters, and the government authorities qualify as person aggrieved as per Section 61 of the IBC. The Supreme Court, in fact, clarified that the word written there is any person aggrieved under Section 61, and it is very broad and indicates no rigid locus requirement to institute an appeal. So therefore, other than the successful resolution applicant, the successful resolution applicant, in fact, submitted a resolution plan and the same has been approved. Other than the successful resolution applicant, everyone else is aggrieved person under Section 61. So therefore, any appeal filed by JSW Steel was not considered as valid. So this was the one question of law, and the court in fact clarified that once the CIRP is initiated, it becomes a collective proceedings in REM where all creditors, ex-promoters and ex-directors are necessary stakeholders. So therefore, that one law point is completely clarified, that it is broadened and it is the stakeholders' right. Now, the second question of law was whether successful resolution applicant can appeal against approval of its own resolution plan. That the Supreme Court said that the successful resolution applicant whose resolution plan has been approved cannot be considered as a person aggrieved. So that we've already discussed. And therefore, the specific grounds that these grounds relate to the contravention of law, material irregularities by the RP, improper provisions for operational creditors or CIRP cost or non-compliance with broad criteria. That is what should be the reasons. But how can a successful resolution applicant prefer an appeal? That is something which is not digested by Honorable Supreme Court. And the third question of law in this case is whether the CIRP timelines stipulated under Section 12 are mandatory and the consequences of their violation. The court decision says that these timelines are mandatory. The court reiterated that the period are mandatory and cannot be extended beyond the maximum limit, which was 270 days on those days, and now it is 330 days, including this 90-day extension. Now, the consequence of non-compliance is the court found that the application for approval of the plan was filed with the NCLT after the expiry of 270 days period, which was a gross non-compliance and a grave error of law committed by both the RP as well as the NCLT in approving the plan. So this was one issue. One, that the SRA should not file an appeal. Number two, timelines are mandatory. Then we say the next question of law was whether the resolution plan that does not provide for prescribed treatment to operational creditors as required under Section 30 subsection 2, the court was very clear that there is nothing like equitable treatment to operational creditors. Section 30 subsection 2 is very clear that in case the company goes into liquidation, what would be payable to the operational creditor, that must be paid, and that should be paid on priority. So therefore, there is nothing against operational creditors in this resolution plan. The court's finding that the RP should have confirmed in the resolution plan in Form H that the operational creditors were paid according to Section 30, subsection 2 and Regulation 38, whereas the RP in this case has not specifically said that. That is the only non-compliance by the RP, but the rights of the operational creditors are not tempered. The rights of the operational creditors are very well intact, that in case the liquidation value, in case the company goes into liquidation, if there is any amount which could have been distributed to the operational creditor, that will be distributed to the operational creditor. And then the finding of the NCLT roles. Now, the court's finding on the NCLT role is that it is NCLT's verification failure. NCLT, while approving the plan under Section 31, had failed to verify whether the plan met the requirement under Section 30, subsection 2. That is the requirement for rejecting the plan. Minimum amount which is required to operational creditors, that needs certificate, and also priority needs to be given. So the RP's duty is to confirm whether the plant is conforming to Section 30, subsection 2 and 30, Regulation 38, and consequence of the failure, it has to be reported. COC's also duty is to verify all the legal compliances are done or not. Even NCLT's duty is also the same. Next question of law comes is whether the NCLT, NCLAT has jurisdiction under the IBC to review, to interfere with actions taken by authorities under other statutes such as PMLA, particularly in the light of Section 32, capital A of the IBC, and findings of the NCLAT's action. And now, the Honorable Supreme Court says in this regard that the NCLT or NCLAT does not vest with the powers of judicial review over decisions taken by the statutory authorities in the realm of public law. PMLA is a public law. Any kind of offenses committed by earlier promoters, and that's also a public law. But the jurisdiction of NCLT and NCLAT, which is mentioned in Section 60, subsection 5, which says that all the subjects arising out of or in relation to the insolvency resolution. Now, in this particular case, the resolution plan was approved under Section that was approved by NCLT. And after the NCLT resolution plan approval, the Enforcement Directorate, in fact, Enforcement Directorate attached the assets. Now, what NCLT is doing, NCLT is only trying to invoke Section 32A, which is part of IBC. And anything which is part of IBC, according to others' opinion which are coming from the public at large, as per the newspapers, the opinion is Section 32A is a part of IBC, and the adjudication also has to come from NCLT, adjudicating authority, or appellate authority. That's what is public. However, in fact, Supreme Court says that NCLT or NCLAT does not have any power to review the decisions taken by the statutory authorities. In fact, in one of my other cases, where the special court has already given consent to deattach, yesterday only the Enforcement Directorate's lawyer appeared before NCLT to reiterate that please record in the order that although we have given the consent to deattach the asset or release the assets in favor of the liquidator, but it must be mentioned in the order that Section 32A was not applicable as per the judgment of Bhushan Power. That the lawyer said that it must be recorded in the order. However, we have given the consent. So therefore, that is also one of the issue which has actually been clarified, that for 32A, the NCLT or NCLAT doesn't have any power, although the judgment of Shiv Charan is already pending before Hon'ble Supreme Court, which is clearly on Section 32A. Once the resolution plan is approved and the resolution applicant is not something which is related to the promoters or any person whose name is mentioned in the charge sheet, therefore the all other earlier attachments, everything would be clear. Now, the next question is whether the NCLT or NCLAT has the jurisdiction to grant modifications, waivers, or extensions post approval of the resolution plan, and whether such powers conflict with the principle of commercial wisdom and finality under the IBC. Now, what has happened is that after the approval of NCLT, the COC again passed a resolution for extending the implementation period. In fact, originally it was 2019. It was extended to 31st March 2021. Now, whether the COC has the power to modify the resolution plan after it is approved by NCLT, the Honorable Supreme Court said no. There is no power available with Committee of Creditors. There is no power available with NCLT. There is no power available with NCLAT to modify a resolution plan which has already been approved. So therefore, this was something which was a great issue. It was a bigger issue, how the implementation period can be extended on the basis of voting, and that voting after the resolution plan was approved by NCLT, whether there was any kind of COC at that time when the resolution plan is approved, although it was pending an appeal, but then this was also one of the questions which was there. So this question and the court's concern on the COC role was also challenged. That the COC, in fact, the court finally said that all these resolution plans are binding and it cannot be changed. Regarding ABIDA, as I said, that it was the decision of the court was that it is not decided. So resolution plan was rejected, and it was directed NCLT will start the liquidation proceedings. So when we actually talk about the learnings from this case, we can say one, that in Section 29A, the RP should very specifically say that rather than placing the facts on record, should very specifically say whether the resolution applicant is eligible or not. That is one thing. Second, once the resolution plan is approved by NCLT, thereafter, the NCLT or NCLAT does not have any power to modify the resolution plan or change or waive any other things. Then it has to be completely compliant. It has to be complied with. It has to be implemented. Then even the uh, one that the resolution plan becomes binding, then SRA's responsibility is to implement it, and no delay can be excused, and therefore the judicial stay is required, and the IBC is silent about the post approval modification. The the Supreme Court says that the IBC is silent about one part, whether the on the implementation phase, but tribunals must not grant excessive leeway to successful resolution applicants. The tribunals must exercise discretion sparingly and with the strict scrutiny when handling post-approval requests. So modification should be restricted. Then all the adherence to the law should be strict. The timeline should be strict. The restraint, this is all the various learning that we have seen, the improper treatment. So all this we have seen that this is something which is a judgment, and now we can actually see the persons aggrieved. We have also discussed procedural failures. We have discussed RP's failure. We have discussed, and COC's oversight. At that also the SRA's obligations, SRA's lapses. All this we have discussed, and now we can see this impact of this judgment when we see the impact. Now, according to the media sources, the government has expressed internally that there are many errors in the judgment and therefore a review is warranted. The government has said that the review is warranted. And IBBI and the Finance Ministry are assessing the broader implications of the ruling on future IBC cases, the potential wider consequences on the overall insolvency ecosystem, and precedent-setting implications for the future IBC cases. Now, one part which according to my opinion, that the Supreme Court is right in the case of Jet Airways and also in the case of Bhushan Power, that the successful resolution applicants are in fact intentionally delaying the implementation of the resolution plans. They are, once the resolution plan is passed in their favor, then they again try to take some more benefits and some more waivers and some more modifications. That is something which should have been restricted by Honorable Supreme Court. And in case we don't restrict that, then most of the successful resolution applicants, after the resolution plan is approved by NCLT or even approved by the Committee of Creditors, they would start seeking further modifications, or they would start further negotiations. That virus actually can spread around to all the resolutions in case it is not plugged together, in case it is not corrected. So one part of this judgment, which I liked personally, which I have seen in many other cases, the successful resolution applicants are in fact delaying the implementation, which impacts the creditors. But the creditors at that particular time are mostly left with no options. So therefore, they actually have to succumb to the pressure of SRA. So therefore, they allow modification, and even NCLT also have been allowing modifications. However, the financial services sector, Mr. M. Nagaraju has passed a statement that government is studying the judgment and exploring all available options. There is a concern within the government that the judgment could dampen business sentiments in the country. He further states that there are significant implications of the transaction if the transaction is unbound. Taxes have been paid, capital expenditure have been initiated, and funds have been deployed. The practical challenges of returning the money are enormous. Because see, when we talk about 19,450, which has been distributed to the creditors, how the money will come back? In fact, the lawyer of Committee of Creditors presented a affidavit before the Supreme Court that in case the resolution plan is not approved, the creditors will return the money back to the SRA. And the government officials also believe that the judgment, in fact, mischaracterized the roles of COC, NCLT, NCLAT, and RP. They argue that the allegations of misconduct and procedural lapses are not entirely factual or justified, and the COC or the successful resolution applicant is expected to file a review petition in the Supreme Court in 2 weeks. The government has also contended to the media that the Supreme Court failed to apply the clean slate doctrine under Section 32, capital A, properly. And they asserted that the JSW Steel should not be penalized for past offenses committed by Bhushan Power. The judgment appears to conflict the precedents like SR Steel and Ghanshyam Mishra cases, and the concerns over jurisdiction under PMLA. The court held that NCLT, NCLAT exceeded their jurisdiction by saying ED action under PMLA. The center believes the tribunal acted within their powers, especially post-approval of the plan under Section 32A. So their concern, the concerns of the central government is that it could open floodgates for revisiting closed IBC resolutions, creating regulatory uncertainties. Now, what is expected legal actions? One, that the committee of creditors or successful resolution applicant is expected to file a review petition before Honorable Supreme Court within 2 weeks. But before that review petition is filed, the erstwhile management of the company has already filed an application before NCLT Delhi for commencing the liquidation proceedings of the company. Regarding Section 32A, the government has contended to the media that the Supreme Court failed to apply clean slate doctrine under Section 32A properly. They asserted that the JSW Steel could not be penalized for the past offenses committed by Bhushan Steel. Then the judgment also appears to be having conflicting judicial views, as conflicting from SR Steel and Ghanshyam Mishra. PML jurisdiction, we've already said. And then the one, as that we have this review petition, which is under Article 137 of the Constitution of India, and therefore it is partly aggrieved by a final judgment or order of Supreme Court, may file a routine. Time limit is within 30 days. And grounds of the review petition, which probably in this case would not be applicable. One is the error apparent. Error apparent on the face of a record. I don't think there is error apparent. Everything has been discussed in the order. A discovery of a new evidence and an important matter or evidence not within the knowledge at the time of the original hearing, that is also is not the case in this particular judgment. Other sufficient reason and hearing process, heard in chambers. Normally, these review petitions are heard in chambers. And therefore, this is something that we are expecting, that nothing will happen in review petition because there is no error apparent from record, there is no new fact, and there is no sufficient reason that the review petition could be admitted. Now, the next legal remedy available is curative petition. Curative petition, when we talk about curative petition, in fact, it is only evolved through judicial pronouncements. And it is not statutory. It is not there in the Constitution, but it is only through the judicial pronouncement. And the one original case, which was in the case of Rupa Ashok Hurra versus Ashok Hurra in 2002, when this curative petition concept was, in fact, pronounced by Honorable Supreme Court. Now, it can be filed only after the review petition, and it is an extraordinary remedy to prevent abuse of process or to cure gross miscarriage of justice. The basic requirements of a curative petition would be natural justice violation. Now, in this case, the natural justice could be, number one, that all the creditors are in favor of this resolution. Number two, government says that 32A is applicable in this case. Three, the successful resolution applicant has already invested on this particular company, and for enhancement, for various capital expenditure, and also for increasing the capacity by about 70%. Conflict of interest, the judges failed to disclose any conflict of interest. That is also something that actually can be argued. The certification, normally this the curative petition can be heard only, it can be heard by three most senior judges of the Supreme Court, including those from the original bench, in case the uh, Bela, Justice Bela Trivedi, in case, and the other uh, Justice Sharma, in case they would be available at that time, they would have to be part of this bench. And also, the curative petition has to be certified by a senior advocate, and it will be heard in chambers. It will not be heard in public. Now, DC, as I said, Sanjay Singhal has already filed an application for commencement. And as I said, the creditors, in fact, as per the newspaper report, the creditors, especially State Bank of India, Punjab National Bank, and the Asset Care Reconstruction Enterprises, they are also evaluating their options. They are also engaging with the lawyers, because see, for them, it will be a very big stress. It will be a kind of future litigation, how the interest would be paid by the banks when the return money will be returned back to SRA, and how this kind of profit for all this period will be kept. Because see, all this period, other than 2,000 crores of EBITDA, in fact, the company has been making profits after even 2021. And for the last 4 years, it is showing the profits. So that also has to be seen how it will be managed. So therefore, all this can be a part of our argument before the curative petition. So it is the government is also saying that it actually can have it actually can have a very complex judicial issues in case there is no relief which may come from Hon'ble Supreme Court in curative petition. So this is what is all. Ankit, I think we can talk about some of the questions in case we can.
No, I will like to kind of talk about that. Let's look at a scenario where the Supreme Court, let's say, doesn't change, Honorable Supreme Court doesn't change the stand on this judgment. Liquidation starts. Now, when liquidation starts, the liquidator gets appointed. Now, how will the liquidator look at everything? And what is the possible presentation that can come before the liquidator? Now, imagine that in this case, the company being a profitable company, there is unlikely to be any unpaid CRP cost, or there any even the IMC period. If there is any cost incurred, most probably it has been incurred out of the profits of the company. Now, when we come to additional capital infusion that have been done by JSW, now that additional capital infusion must have been done through some method, and that is of course has been done either during the CRP period or the IMC period. Now, can the capital infusion that has been made by the company during the IMC period, monitoring committee period, be treated as an interim finance under the law? In case it is treated as an interim finance, then we have an interim finance to be paid back as part of the, which is of course as part of the CRP cost. We have then the liquidator auctions the entire company as a going concern, and creditors are likely to get more money as compared to what they got during the CRP period. Because in liquidation, they will get the entire company, the buyer will get the entire company, and this company will be a better company as compared to as on the CRP date. So I am of the personal opinion that when this company is liquidated during the liquidation period or liquidation stage, COC members will set to gain. JSW is likely to get their interim finance back. And so what I'm trying to say is that, of course, it kind of creates a bad precedence for a resolution applicant in the country, that, oh, my resolution plan that I submit can be reversed at any stage later on. But I believe with this process in place, what JSW will lose, what the resolution applicant JSW will lose is the effort made to revive this company in the last 3 months or 4 years or 3 years, 4 years, that is what they will lose. They will also maybe lose some interest element on the interim finance that they have kind of made to the company. But creditors perhaps will not lose anything.
Ankit, you're absolutely right. But the only thing is, like, maybe whenever there is a induction of funds after the approval of a resolution plan, there is no resolution under Section 28 which would have been passed by the Committee of Creditors, and it could not have been. It definitely inducted as a interim finance. But I think the best outcome of a curative petition, and because it will be a kind of abuse of justice to GSW, the GSW can always argue that whatever GSW has invested, that should be considered as interim finance. Whatever money has been invested on the plant for capex, that should also be considered as the interim finance. And the interest rate also can be decided by Supreme Court, and that can be equivalent to the cost of capital to JSW. So that is where I think in case the government definitely would like to tell a lesson to most of the successful resolution applicants who are delaying the implementation, then this can actually clarify that we are not interested in your money. You can take back your money. But what we want is that in future, no successful resolution applicant will delay the implementation by using the judicial procedures or the judicial forums. That would be the best part in this. As far as the other parts is concerned, the Supreme Court has said, Abida, we are not taking a decision. 32A, we are not taking a decision. We are not expressing an opinion, because that particular order that we passed in December 24, that was based on the consent given by ED. So that is the issue which is open. Similarly, 2,000 crore is not being handled. The operational creditors issue is very clarified that the operational creditors are only supposed to get which is available to them in case the company is liquidated. So now, in the case of liquidation, in case there will be more money available, more than the claims they will get. So that issue is also not changing. So the only thing which changes as far as this insolvency regime is concerned, number one, that the successful resolution applicant cannot delay. Number two, the COC cannot modify or give any further waivers or relaxation after the approval of the NCLT. Three, NCLT or NCLAT doesn't have any power to modify the resolution plan. So these are the major things which actually are the learning. But there is, as far as the RP is concerned, RP is only one learning to the RP, that RP should definitely give a certificate that under Section 29A, this particular applicant is eligible. Secondly, he should not simply place the facts on record. He must give certificate that yes, it is a complete. And as far as this operational creditors are concerned, the RP definitely should say that the operational creditors are getting their dues as per Section 30, subsection 2, and as per Regulation 38. So these are the only precautions for the RP. And for the delay, it is the lesson for the successful resolution applicants, for the COC and for NCLT, that they don't have any power to modify or give further negotiation or further concessions. Yes, Ankit.
No, sir, there's so many questions. There are about 17 questions. A few of these observations are very important. So apart from the impact on the resolution applicant and the creditors that we discussed, we also have another issue that there must be some creditors who finance the acquisition and who have a charge on the assets after JSW paid the creditors, existing creditors in full, and they must have vacated their charge during the IMC period. So that's another problem that they will have to take care of. Another comment which is very interesting that has come in is that the OCs will most probably lose and the FCs or the secured creditors will most probably gain, because in liquidation 53, when you practice the 53 waterfall, OCs will get almost no money if the money is still payable to the financial creditors or the secured creditors. So that's again another observation that is important that has come in.
But that is okay, Ankit, that Supreme Court has also upheld that part. Supreme Court has said that other than Section 30, subsection 2 or Regulation 38, there is no entitlement of operational creditors. And
That's
that
okay.
entitlement is And that
We're talking
entitlement
about the
is that,
liquidation. Yeah.
yes,
Talking about what will happen in liquidation, how liquidation will treat different stakeholders differently. So OCs will be treated differently, because if OCs were supposed to get something during the resolution plan, today they will not get that entitlement under the liquidation process.
yes. In liquidation process, the OC will not get anything.
Similarly, in liquidation, a question that comes out is what happens to those creditors who have become creditors after the resolution plan approval? So will they also be treated as interim finance, because some creditors might have given loans to this company after the resolution plan was approved?
Now, let us understand the legal position. The legal position is after the commencement of CIRP, anything which is any liability which is incurred, any liability which is incurred will be completely paid. That is what is
Yeah.
the law. So any liability which has been incurred by Bhushan Steel, maybe with regard to the equity, maybe with regard to the maybe with or maybe the corporate loan that they may have raised for capex, that actually will be considered as liability raised during CIRP period and will have to be paid completely. It will become part of the CIRP cost. And even to my earlier opinion that the in curative petition, the Supreme Court can clarify that all these liabilities, all these suppliers who have supplied goods during CIRP period, because the CIRP is still continuing till the liquidation order is passed, the CIRP is still continuing. And during all this period, the company is operating. The company is doing a manufacturing of 3.37 million tons of steel. And that company is actually generating a bidder. And that means the company is also buying and selling goods. So there are debtors and there are creditors. All those will be considered as liability created during CIRP period and will have to be paid in full.
So the implementation period that you're saying, that post CRP, post the resolution plan approval, the implementation period will effectively get merged as CRP period, and that's how the liquidator will look at the entire liabilities and the
Not not
scenario of the
not that
company.
I'm saying that. Not that I'm saying that. Presently, also the company was getting operated under a monitoring committee. The RP is still continuing. RP is still
Yeah.
continuing. In case we see the IBBI, RP is still continuing. That means the CIRP period is continuing. Then only liquidation can be started, not otherwise.
Yeah, like there is a way to say that CRP period was continuing, or there is a way to say that CRP period ended on the resolution plan approval date, and after that, the monitoring or the implementation and monitoring phase had started. That's why I was saying that implementation and monitoring phase, we can today merge that as CRP period, in case we are looking at how to look at all these liabilities and changes since
I
the
think that is
resolution.
something that we need to see whether the RP was still continuing or not, because that minor detail that I couldn't see whether the RP was continuing or not, because that we can see on the IBBI website whether the RP is still continuing as RP in this case or not.
So most
Because that
probably, I
is
believe,
something very important.
yeah. All right, I think we have so many questions, but I think we are running out of time. Time is also of essence. We have some raised hands. No, we don't have any raised hands per se. So I think we can request our listeners to maybe, share these questions offline, and we will be happy to take them offline.
Yes, thank you very much. This analysis is in fact very, very important for everyone, and especially whether this will be considered as CIRP cost or not. I mean, I will also check on the IBBI website whether the RP is continuing or not. Will depend upon whether the RP is continuing or not. In case the RP is continuing as monitoring committee member or chairman, then this particular period, then everything will be new. Then all the claims will be new. Then I think, as I said, in the curative petition, then the Supreme Court can kind of provide a solution. Anything which was invested by SRA, that can be considered as interim finance. That would be the best solution in case RP is not continuing. In case the RP is continuing, then there is no question. Then the law provides for all these payments on priority as CIRP cost in liquidation process also. Yes, thank you very much. And thank you very much for joining this particular episode in huge numbers. I think we have a huge, and we broke the record today, as this discussion was very, very popular. So this was very important. So the total numbers that joined together has actually broken all the records in the past. Thank you very much. And we are definitely very happy that everyone has joined. Thank you.
Thank you, everyone. Thank you.